The Corpus Juris Civilis is the modern name for a collection of fundamental works in jurisprudence, issued from 529 to 534 by order of Justinian I, Eastern Roman Emperor. It is also sometimes referred to as the Code of Justinian, although this name belongs more properly to the part titled Codex Justinianus. The work as planned had 3 parts. The code is a compilation, by selection and extraction, of imperial enactments to date. The digest or pandex is an encyclopedia composed of mostly brief extracts from the writings of Roman jurists, and the Institutes is a student textbook, mainly introducing the code, although it has important conceptual elements that are less developed in the code or the digest. All 3 parts, even the textbook, were given force of law. They were intended to be, together, the sole source of law. Reference to any other source, including the original texts from which the code and the digest had been taken, was forbidden. Nonetheless, Justinian found himself having to enact further laws, and today these are counted as a 4th part of the corpus, the Novella Constitutionis. The work was directed by Tribonian, an official in Justinian's court. His team was authorized to edit what they included. How far they made amendments is not recorded and, in the main, cannot be known because most of the originals have not survived. The text was composed and distributed almost entirely in Latin, which was still the official language of the government of the empire in 529 to 534, whereas the prevalent language of merchants, farmers, seamen, and other citizens was Greek. By the early 7th century, the official government language had become Greek during the lengthy reign of Heraclius. How far the Corpus Juris Civilis or any of its parts was effective, whether in the East or in the West, is unknown. However, it was not in general use during the early Middle Ages. After the early Middle Ages, interest in it revived. It was received or imitated as private law, and its public law content was quarried for arguments by both secular and ecclesiastical authorities. This revived Roman law, in turn, became the foundation of law in all civil law jurisdictions. The provisions of the Corpus Juris Civilis also influenced the canon law of the Church. It was said that Ecclesia vivat lege Romana, the Church lives by Roman law. Influence on the common law systems has been much smaller, although some basic concepts from the corpus have survived through Norman law, such as the contrast, especially in the Institutes, between law and custom. The corpus continues to have a major influence on public international law. Its 4 parts thus constitute the foundation documents of the Western legal tradition. The 4 parts. Codex. The Codex was the first part to be finished, on the 7th of April 529. It contained in Latin most of the existing imperial constitutionis, back to the time of Hadrian. It used both the Codex Theodosianus and the 4th century collections embodied in the Codex Gregorianus and Codex Hermogenianus, which provided the model for division into books that were themselves divided into titles. These works had developed authoritative standing. This first edition is now lost. A second edition was issued in 534 and is the text that has survived. At least the second edition contained some of Justinian's own legislation, including some legislation in Greek. It is not known whether he intended there to be further editions, although he did envisage translation of Latin enactments into Greek legislation about religion. Numerous provisions served to secure the status of Christianity as the state religion of the empire, uniting church and state, and making anyone who was not connected to the Christian church a non-citizen. Laws against heresy. The very first law in the Codex requires all persons under the jurisdiction of the empire to hold the Christian faith. This was primarily aimed against heresies such as Nestorianism. This text later became the springboard for discussions of international law, especially the question of just what persons are under the jurisdiction of a given state or legal system. Laws against paganism. Other laws, while not aimed at pagan belief as such, forbid particular pagan practices. For example, it is provided that all persons present at a pagan sacrifice may be indicted as if for murder. Digesta. The Digesta or Pandecti, completed in 533, is a collection of juristic writings, mostly dating back to the 2nd and 3rd centuries. Fragments were taken out of various legal treatises and opinions and inserted in the digest, in their original context. The statements of the law contained in these fragments were just private opinions of legal scholars, although some juristic writings had been privileged by Theodosius II's Law of Citations in 426. The digest, however, was given complete force of law. Institutionis. As the digest neared completion, Tribonian and two professors, Theophilus and Dorotheus, made a student textbook called the Institutions or Elements. As there were 4 elements, the manual consists of 4 books. The Institutionis are largely based on the Institutionis of Gaius. 2/3 of the Institutionis of Justinian consists of literal quotes from Gaius. The new Institutionis were used as a manual for jurists in training from the 21st of November 533 and were given the authority of law on the 30th of December 533 along with the digest. Novellae. The novellae consisted of new laws that were passed after 534. They were later reworked into the Syntagma, a practical lawyer's edition, by Athanasios of Emesa during the years 572 to 77. Continuation in the East. The Byzantine Empire was the medieval continuation of the Roman Empire in the East, and continued to practice Roman law as collected in the Corpus Juris Civilis. This law was modified to be adequate for the new social relationships in the Middle Ages. Thus the Byzantine law was created. New legal codes based on Corpus Juris Civilis were enacted. The most known are Ecloga, enacted by Emperor Leo the Isaurian; Prohyon, enacted by Emperor Basil the Macedonian; and Basilica, started by Basil the Macedonian and finished by his son Leo the Wise. The last one was a complete adaptation of Justinian's codification. At 60 volumes it proved to be difficult for judges and lawyers to use. There was need for a shorthand version. It was finally made by Constantine Harmonopoulos, a judge from Thessaloniki, in 1345. He made a short version of Basilica in 6 books, called Hexabiblos. Serbian state, law and culture was built on the foundations of Roman Byzantium. Therefore, the most important Serbian legal codes, Zakono Pravilo and Juson's Code, transplanted Roman Byzantine law included in Corpus Juris Civilis, Proeron and Basilica. These Serbian codes were practiced until the Serbian despotate fell to the Turkish Ottoman Empire in 1459. After the liberation from the Turks in the Serbian Revolution, Serbs remained to practice Roman law by enacting Serbian Civil Code in 1844. It was a short version of Austrian Civil Code, which was made on the basis of Corpus Juris Civilis. Recovery in the West. Justinian's Corpus Juris Civilis was distributed in the West but was lost sight of. It was scarcely needed in the comparatively primitive conditions that followed the loss of the Exarchate of Ravenna by the Byzantine Empire in the 8th century. A 2-volume edition of the Digest was published in Paris in 1549 and 1550, translated by Antonio Augustini, Bishop of Tarragona, who was well known for other legal works. The full title of the digest was Digestorum seu Pandectorum Tomus Alter, and it was published by Apud Carolam Guiards. Volume 1 of the digest has 2,934 pages, while Volume 2 has 2,754 pages. The only Western province where the Justinianic Code was effectively introduced was Italy, following its recovery by Byzantine armies. But a continuous tradition of Roman law in medieval Italy has not been proven. Historians disagree on the precise way it was recovered in northern Italy about 1070. Legal studies were undertaken on behalf of papal authority central to the Gregorian reform of Pope Gregory VII, which may have led to its accidental rediscovery. Aside from the Littera Florentina, there may have been other manuscript sources for the text that began to be taught at Bologna, by Peppo and then by Irnerius. A technique was to read a passage aloud, which permitted his students to copy it, then to deliver an excursus explaining and illuminating Justinian's texts, in the form of glosses. Irnerius' pupils, the so-called Four Doctors of Bologna, were among the first of the glossators, who established the curriculum of medieval Roman law. The tradition was carried on by French lawyers, known as the Ultramontani, in the 13th century. The merchant classes of Italian communes required law with a concept of equity, and law that covered situations inherent in urban life better than the primitive Germanic oral traditions. The provenance of the code appealed to scholars who saw in the Holy Roman Empire a revival of venerable precedents from the classical heritage. The new class of lawyers staffed the bureaucracies that were beginning to be required by the princes of Europe. The University of Bologna, where Justinian's code was first taught, remained the dominant center for the study of law through the High Middle Ages. Referring to Justinian's code as Corpus Juris Civilis was only adopted in the 16th century, when it was printed in 1583 by Dionysius Gothofredus under this title. The legal thinking behind the Corpus Juris Civilis served as the backbone of the single largest legal reform of the modern age, the Napoleonic Code, which marked the abolition of feudalism. The Corpus Juris Civilis was translated into French, German, Italian, and Spanish in the 19th century. However, no English translation of the entire Corpus Juris Civilis existed until 1932, when Samuel Parsons Scott published his version, The Civil Law. Unfortunately, Scott did not base his translation on the best available Latin versions, and his work was severely criticized. Fortunately, Fred H. Bloom did use the best regarded Latin editions for his translations of the Code and of the novels.